State's Attorney Stephen Sedensky contends that what happened during the Newtown shootings was child abuse. Thus, these tapes should remain confidential in accordance with certain state child abuse laws. But any child abuse would have to have been reported to the Department of Children and Families.
And was there any such report?
We can find no record of such a report, and no one has any recollection of it.
Counsel representing the Associated Press cited federal law in making their case about a classification of abuse.
And child abuse there is defined with respect to a caregiver. I'm paraphrasing a little bit to simplify it, but it's the same idea that is relevant to DCF. It has to be a caregiver.
The state's response? Connecticut's definition of child abuse is the only one that matters.
What applies is the general definition of child abuse, not the DCF operational definition for their employees and when they do an investigation.
The Associated Press lawyer then cited the Cheshire home invasion as one example of information in a case involving minors being released soon after.
They were made public both before the criminal case and during the criminal case. They were made public by the state's attorney's office. They were made public in all sorts of different ways. All of that would be contrary to counsel's argument.
Disingenuous is how an attorney representing Newtown described the Associated Press lawyer's assertions that they simply want access to the tapes to help the public understand police response.
The reason people are going to listen to these calls on YouTube and on CNN is not the time, the response of the responders. It's going to be a voyeuristic interest in what happened.
In order to rule whether or not to issue a stay, the judge said he himself needs to listen to the 911 recordings.
Because I think that that's necessary to measure many of the contentions that Attorney Sedensky has made here today, to allow me to consider the adequacy of the Commission's findings.
Tony Terzi, Fox, Connecticut.